welcome to the deep dive. Today, we're walking right into what feels like a classic neighbor dispute. But the stakes are actually, well, they're existential. We're talking about that massive, maybe hazardous tree on your neighbor's property, the one that looks like it's just waiting for the next big storm to take out your fence, your deck, or, worse, your living room.
And this really isn't just about a simple property line disagreement, is it? This deep dive is about liability. It's about safety. And it's about using DC tree law specifically for you, the homeowner who's actually in danger, to get some leverage and protect your biggest asset.
Right. So our mission here is to map out the clearest, fastest, most practical path forward. We've got to balance your urgent need for physical protection with the tricky reality that, this person lives right next door. You need results, but you also need a livable relationship, if that's even possible.
Well, we have to start with the fundamental legal framework in D.C. It's actually pretty straightforward. Under the law, the tree belongs entirely to the property owner where the trunk is physically located. That's the starting point.
Okay. So it doesn't matter how far the branches stretch over your deck or how deep the roots go. Your neighbor has primary ownership. And with ownership comes, primary responsibility.
So if they own it and they're responsible for it, why can't I just, hire someone to trim it back when it crosses the line?
You absolutely can. But, and this is a big but, there are immense hidden risks here. D.C. follows what's known as the Massachusetts rule. People often call it the self-help rule.
Self-help? Okay.
It gives you a limited right to cut or trim branches or roots, but only up to the property line. You can't cross that line, and you're the one who has to clean up the debris.
That seems reasonable enough, so where's the risk?
Here's the huge caveat that just traps so many homeowners. If you exercise that self-help right and you trim the tree in a way that damages its health or its structural integrity or, causes it to die, you could be held financially liable for the entire value of that tree. And that can be thousands, sometimes tens of thousands of dollars.
Just for trimming a branch. If it harms the tree, yes. The tree is considered your neighbor's asset. So you're protecting your property, sure, but you have to do it without diminishing their asset.
Okay, so self-help is risky. And it only really solves the inconvenience issue, not the giant hazard looming over my house. That sets us up perfectly for Section 1. Let's move beyond trimming to the core liability of a hazardous tree and the legal idea of negligence.
Right. Since the neighbor owns the tree, the law places a high standard on them. It's called the duty of care. If that tree is diseased, dead, or visibly dangerous, a hazardous tree DC law says that if a reasonably prudent person would recognize the danger, the owner can be held liable for any damages the tree causes.
I have to push back a little on that reasonably prudent person standard, though. How can a court really expect a normal person to know if their tree is sound or has some complex fungus inside? Isn't that an unreasonably high bar?
It is a high bar, and that is exactly why legal precedent is so important here. The landmark D.C. case we looked at is Dudley v. Meadowbrook Inc. And what that case established it's just profoundly critical. It says, once there are visible signs of danger-dead limbs, rot, big cracks, a noticeable lien, the landowner's duty, it shifts. They can no longer claim ignorance. The law effectively says they have an affirmative duty to hire an expert, like a certified arborist, to get the tree inspected.
So the minute they ignore those obvious warning signs, the clock starts ticking on their negligence. They should have known because the law says they should have investigated.
Exactly. The Dudley standard is there to make sure landowners act responsibly. It prevents them from using ignorance as a shield after something terrible happens.
Okay, this brings us to the tactical action.
Yeah.
If we know the neighbor has this duty of care, what are the absolute actionable steps you, the listener, must take right now to build a rock-solid negligence claim? This is where the documentation strategy comes in.
Documentation is everything. It's the foundation of your claim, and formality matters so much here. Step 1. Send a formal written notice documenting the hazard. And this can't be an email. It can't be a conversation over the fence.
It has to be official.
It must be sent via certified mail with a return receipt requested.
Why is that little return receipt so important? Why is it the key document?
Because liability here, it hinges on establishing knowledge. That return receipt is definitive proof, signed by them, that your neighbor got your warning on a specific date. And that date, that's the moment the negligence clock starts running loud and clear. After that, they are formally on notice. Their failure to act becomes much, much harder to defend in court.
Okay, step 2 is visual evidence.
Yes. Clear, time-stamped photos, videos, Focus on those danger signs from the Dudley case. Large, dead limbs hanging over your house, rot at the base, heaving roots that are breaking up your property, or, any damage that's already happened, like a buckled retaining wall or a broken fence.
And step 3 is the expert opinion. This costs money, but it sounds like it's absolutely necessary.
It's non-negotiable, not if you're trying to establish negligence in a case that's going to be disputed. You have to get a formal arborist's report that confirms the hazard. Specifically, look for an ISA-certified arborist, International Society of Arboriculture. Their certification just carries more weight in court.
We looked at the numbers on this. The average cost is around, $875 for a report, but I saw fees ranging wildly from like $75 up to $5,000. What's with that massive difference?
That variance is all about the scope of the work, the depth of the assessment. A $75 fee might just be for a basic visual risk assessment, a quick look for obvious stuff. But if the hazard is, say, structural or internal, the arborist might need to do specialized testing.
Like what?
Things like resistance drilling or sonic tomography to basically scan the inside of the tree for decay. These are expensive, invasive tests that can really push the cost up into the thousands. But you want whatever level of assessment you need to definitively confirm the hazard.
Right. And now we also need to bring in government oversight, because this gives you a really powerful tool, no matter how cooperative your neighbor is.
Absolutely. We have DC's hazardous tree regulations. It's DC Code Section 8651.06. And this law says property owners cannot permit a hazardous tree to stand. It empowers the city. If the mayor's office, through the right agency, notifies the owner and they fail to act, the district can take corrective action.
Meaning the D.C. government will come and remove the tree.
They will. You contact the D.C. Department of Transportation, their Urban Forestry Division, DDOT. They'll investigate. If they agree it's an imminent hazard, they serve a notice to the neighbor. The notice demands removal, often within 10 days. If the neighbor ignores it, the district hires a contractor, removes the hazard, and bills the owner. And here's the powerful part. If that bill goes unpaid after 60 days, it becomes a tax lien on the neighbor's property.
Wow. Okay, that is significant leverage. It affects their ability to sell or refinance their home. So the tactical documentation is done. We've got the government enforcement option. Now, how do we turn all that leverage into a safety solution without just diving straight into a huge legal battle? This brings us to that core choice: mediation or litigation.
When you are facing a literal, looming, destructive hazard, you need speed. You need efficiency. And that's why mediation should almost always be your first step. It's a voluntary, confidential process where a neutral third party, the mediator, facilitates a conversation. They aren't a judge. They don't impose a solution. They just help you find your own.
Let's talk about the dollars and the speed here, because this is where the comparison just gets shocking.
It's staggering. If you try to resolve this through formal litigation in civil court, the source material says legal fees can easily exceed $50,000.
$50,000, just
And that's before you even get to trial.
$50,000 to resolve an argument about a tree that might only be worth $5,000 itself? How is that possible? What makes it so expensive?
It's the procedures. It's the formal litigation process. Think about discovery. Document requests, interrogatories, and the big one, depositions. For a deposition, you need lawyers from both sides, a court reporter, and your arborist, who's now an expert witness. Each one of those can cost thousands of dollars. Then add in motion hearings, filing fees. The attorney hours just explode.
And compared to that, mediation costs.
What? A tiny fraction, a few hundred to maybe a few $1,000s. And some of the court-connected services in D.C. might be minimal cost or even free. The financial incentive is just immense.
What's fascinating is the speed factor. In a safety threat situation like this, speed is everything.
It is paramount. A court case can easily drag on for 2-3 years or even longer. And the whole time, that hazard is still there. Mediation, because it's focused and not adversarial, can often be done in a single day. Or maybe over a couple of weeks. When you have a giant dead branch hanging over your roof, weeks beat years. Every single time.
Can you walk us through the mechanics? I mean, how does a mediator manage the tension when the neighbors basically hate each other?
Well, it usually starts with a joint session. Mediator sets ground rules. Both sides say their piece. But the real work, it happens in what are called private caucuses. This is critical. The mediator separates you. And you can talk about your real concerns, your fears, your flexibility, alone with the mediator.
Without the neighbor hearing it.
Exactly. The mediator then shuttles back and forth, conveying offers, exploring interests, and just neutralizing that emotional conflict.
And the confidentiality rule encourages people to actually talk, right?
Yes. Anything said in mediation, any offer you make, any weakness you admit, it's all strictly confidential. It can't be used in court if you end up there later. It means you can be honest without worrying you're hurting a future lawsuit.
But I think the most powerful advantage of mediation is the creativity of the solutions. A judge can really only award money for damages that have already happened. What kind of proactive custom solutions can you get in mediation?
The sky's the limit. You aren't just stuck with black-letter law. For instance, instead of just suing for the cost of a damaged fence, mediation might lead to an agreement where the neighbor pays to remove the hazardous part of the tree, and in exchange, you agree to split the cost of installing a professional root barrier. And you could jointly pay a contractor to replace the fence.
That's a real solution. It preserves both parties' interests. It's not about winning money. It's about solving the problem so you can coexist.
Precisely. Or maybe the neighbor agrees to hire their own ISI arborist, and the two of you create a binding joint management plan for the next 5 years. You can negotiate cost sharing, define schedules for removal, specialized trimming, things a court would never order.
Okay, that brings us to Section 3, preserving your rights. We want mediation to work. But if the neighbor is just intractable, or the situation's too urgent for talking, what happens when mediation fails?
The biggest reassurance here is that if mediation hits a dead end, all your formal legal rights are completely preserved. You just walk away. And nothing you said in that room can ever be used against you in court. You then just go back to your formal legal pathways armed with all that documentation we talked about.
So let's detail litigation pathway number 1, the negligence lawsuit in D.C. Superior Court. What are the 5 basic elements you have to prove to sue them?
You're building a case based on that duty of care we mentioned. So you have to establish, 1, the neighbor owned the tree. 2, that they knew, or under that Dudley standard, they should have known the tree was hazardous. 3, they failed to maintain it or inspect it. 4, that failure to act is what caused the damage. And 5, that you suffered measurable damages.
And there's a ticking clock, right? What's the statute of limitations on this?
In D.C., you generally have 3 years. 3 years from the day the damage happened, or from when you discovered it. And given how long litigation takes, you really can't afford to wait.
The amount of damage also changes which court you go to. Let's differentiate between the 2 types of courts you might use.
Right. If the damage is minor, say a branch took out a gate and the repair is a few $1,000s, you can use small claims court. That's for damages of $10,000 or less. It's more informal, it's quicker, usually resolves in 2 or 3 months. But if the tree caused catastrophic damage, structural damage to your house foundation, let's say, and the total repair cost is over $10,000, you have to file in the D.C. Superior Court's Civil Division. And that's the long, formal, expensive process we talked about.
Let's just revisit that government abatement option. It's a powerful path, but it seems to require a pretty extreme threat.
It does. That's litigation pathway number 2, enforcing the D.C. Code through the government. As you said, you contact the DDOT Urban Forestry Division. The key here is that DDOT will only step in for imminent hazards. This usually means the tree is an immediate threat to life or property. If they agree, they serve that 10-day notice. If the owner still resists, DC's power of enforcement is absolute. They will remove the tree, and the bill becomes that tax lien.
And finally, we mentioned another legal tool, the private nuisance claim. How is that different from the negligence claim?
It's a really crucial distinction. Negligence is usually about a sudden failure. The tree falls in a storm because it was neglected. A private nuisance claim is for ongoing, continuous harm. For example, the tree is healthy, but its giant root system is constantly invading your property, cracking your sewer line, buckling your driveway, or is constantly dropping huge debris that causes minor, perpetual damage. That continuous harm is a private nuisance. It's a different legal angle for when the hazard is less about collapse and more about constant encroachment.
This has given us a really clear strategic map. You start with proactive documentation. That builds your legal leverage. Then you pursue the cooperative, fast, controlled approach, which is mediation. And if that fails, you have preserved all your formal legal rights for litigation or government enforcement.
And that control is everything. By spending a few $100s on certified mail and an arborist report, you have fundamentally changed the legal dynamic. You're in a strong position because you've established their duty and their documented failure to act, no matter which path they choose.
So what does this all boil down to for you, the listener, standing in your yard and looking up at that dangerous tree?
Well, if we connect this to the bigger picture, the core tension in these disputes is always control versus enforcement. Think about the strategic difference. In mediation, you keep complete control. You can veto any proposed settlement. You have the final say on the safety solution. But in formal litigation, you are surrendering control entirely to a judge or a jury. They'll just apply black and white law to award you money, maybe years later. So when you're facing a literal physical danger right now, how valuable is it to keep control over that immediate safety solution? You know, a solution that might involve complex trimming or root barriers compared to just winning a damage award years down the line. That choice, the choice of retaining control over your immediate safety, is something for you to mull over as you decide what to do next.